Hello, my name is Ken Robinson. I'm an attorney with the law firm of Robinson Hungate in Boulder, Colorado. Thank you for taking the time to look at this mini webinar on drainage rights, especially as to floodwater conditions. Everyone knows that water flows downhill, but what are the legal ramifications when the flow is obstructed and property damage results either upstream or downstream? During flooding, conditions that historically allowed water to pass unobstructed from one property to another can be overwhelmed. Previously harmless objects in the drainage path become obstacles, and water reroutes without the benefit of proper hydraulic design. So, who is responsible for resulting damage and under what circumstances? The law governing the rights and obligations of the landowners is well developed, but the wide range of property configurations and varying drainage patterns can still make assessment of the legal relationships challenging. Such questions often arise after unprecedented flooding, such as occurred in 2013 in and around Boulder and the Front Range of Colorado. That event demonstrated that we still have a lot to learn about flood risks and how to predict and manage them. The relevant law can provide guidance, as there are well-established legal rights that attend the flow and drainage of water over adjacent properties. The right to have water drain from one property to another is in the nature of an easement. In traditional legal terms, an easement is a form of what is known as a servitude. Black's Law Dictionary defines a servitude as a charge or a burden resting upon the estate for the benefit or advantage of another. In easement law, the benefited property is known as the dominant estate, while the burdened property is known as the servient estate. Thus, a drainage easement benefits the adjacent upstream property, the dominant estate, and burdens the adjacent downstream property, the servient estate. In some instances, though technically not an easement, the downstream property may have a right to require that the drainage from the upstream property be regulated such that the downstream flow will not be destructive. Drainage easements can be established in several ways. First, they can be established by an instrument of conveyance, such as an easement deed. Second, they can be established by a dedication in a subdivision plat or an engineering drainage plan associated with a subdivision. Or third, they can be established by common law, that is, by appellate court rulings known as opinions. It is the latter two types of drainage easements that give rise to most disputes. Colorado law recognizes the right of the owner of an up-gradient property to have surface water drain onto an immediately adjacent down-gradient property by way of what is known as a natural easement for drainage. When natural and historic conditions of drainage are modified or disturbed by construction or development, the law becomes more complex. Generally, the owner of a down-gradient property, that is the servient estate, is allowed to modify the drainage pattern on that property, provided that the modifications do not adversely impact the drainage over the up-gradient property, which is the dominant estate. In a Colorado Court of Appeals opinion, the court summarized the common law of natural drainage easements as follows, and I quote from the opinion: Colorado has always followed the civil law rule, which provides that the owner of upstream property possesses a natural easement on land downstream for drainage of water flowing in its natural course. Also, natural drainage conditions may be altered, provided that water is not sent down in a manner or quantity to do more harm than formerly. Neither the fact that the land concerned is urban rather than rural, nor the fact that the elevation on properties has been lowered without materially altering the natural drainage flow, affords a rational basis for creating exceptions to the general rule. Colorado cases on water drainage have drawn no such distinctions. Note that in the same opinion, the Court of Appeals in the highlighted text indicated that drainage patterns can create drainage easements through the result of urbanization, that is, the construction of improvements that alter the flow over the downgradient estates, particularly in developed areas. Common law is law created by appellate courts in the form of opinions. The common law of access easements also provides for the creation of an easement by way of uncontested use over the alleged servient estate for a prescribed period of time. For example, one case held that a drainage easement can be created by prescription with a prescriptive period of 18 years. Though the primary purpose of a drainage easement is to allow water to flow unimpeded over the dominant estate, there is an attendant but limited right of access over the servient estate in order to maintain drainage areas such that entry onto the servient estate does not constitute trespass. In an instructive 1973 case, plaintiffs brought an action for trespass when the defendants entered plaintiff's property to reopen a ditch. The trial court held that the defendants were acting lawfully in repairing the ditch. The Court of Appeals in that case affirmed the trial court's judgment, stating, quote, "If an owner of the dominant estate does not unnecessarily inconvenience the owner of the servient estate, and use of the easement is not expanded, the owner of the dominant estate may do whatever is reasonably necessary for the enjoyment of the easement, including repairs, ingress and egress, with space for that, as exigency may show." The next set of slides illustrates liability that can arise from the impairment of drainage flow. If the owner of a downgradient property subject to a drainage easement alters the drainage pattern for water flowing from the upstream property, and those changes substantially alter the flow so as to cause the water to back up onto the upstream property, the owner of the downstream property may be liable for damages in a court action. It is important to note that a physical alteration to a drainage area may not cause water to back up except during flood conditions, and thus the impairment may go unnoticed for years. Nevertheless, the servient estate owner may be liable, though the flooding may take place long after the alteration. Also, it is useful to note that in Colorado, the governmental immunity statute does not apply to drainage easement disputes. Thus, even if a downstream drainage blockage is created by a governmental entity, it could still be required to remove the blockage and even be found liable for damages. Upstream property owners have standing, which is the right to file suit to seek recovery of damages for injury resulting from floodwaters backed up by blockage of the downstream drainage. There is a 1995 Illinois appellate court decision which illustrates this. In that case, the homeowners brought an action against the developer of a residential subdivision for injunctive and declaratory relief to have the developer replace drainage channels on their properties with underground drainage systems so as not to flood the plaintiff's land. The city intervened, filing a motion to dismiss, arguing that the plaintiffs did not have standing because of governmental immunity. That is what we also called sovereign immunity. The trial court granted the motion. However, the Illinois Court of Appeals reversed that holding. This is a particularly important concept because the principle is generally that everybody is entitled to his, her, or its day in court. So, that is a short overview of natural easements for drainage from a legal perspective. To summarize, remember, if water naturally flows from one property to another, certain rights and obligations arise for both property owners. What happens on the downstream property may affect water flow over the upstream property, even if only during flood conditions. So my advice is to be careful, be aware, and when in doubt, hire a competent engineer before you see a lawyer. Thank you so much, and good luck.